Okay, back where we started, check on legal reform. These are not opinion posts shown our legal sites to help you find resolution. The justice reform you need is to learn the rules of professional conduct and the code of judicial conduct to obtain due process, a fair trial, effective assistance of counsel, etc. So I go over a lot of laws with you. Okay, so we're going to go to citing a conspiracy against rights under the color of law. Okay, so if you want, you can use this yourself if you want. Okay, gentlemen, quite a few people I've been helping. One condensed it to a minute and a half. What was his name? Juan Cortez. And this is basically what he told the judge, what he was complaining about, conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counsel for ineffective assistance counsel and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. Failure to report is misconduct just as well as failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. The privation of rights in its entirety. It clearly shows the judges and attorneys in my case committed a conspiracy against rights under the color of law, prohibited the willful deprivation of rights or the immunities under the color of law, which prohibits conspiracies to injure, oppress, threaten, or intimidate any person in a free exercise of their enjoyment of any right or privilege secured by the Constitution or laws of the United States. I trust you will live up to your oath and show competence, diligence, expediting litigation as I have meritorious claims and contention. So I strongly stress Rule 3, reporting professional misconduct and maintaining the integrity of the profession. I trust communication will be made for ethical violations and every penalty will be imposed in the public interest as trustees. This is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. Okay, so this is basically explaining what he's complaining about. Canon 2. That's why the judge didn't say nothing. A judge shall perform their duties of judicial office impartially, competently, and diligently. So the judge didn't stop him from saying what he was saying because Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in the proceeding or that person's lawyer the right to be heard. His lawyer wasn't saying anything, so he took it upon himself, and the judge had to give him his right to be heard, just as well as you. Okay, so a judge shall accord to every person who has a legal interest in the proceeding or a right to be heard. Okay, judge shall so we're going. That's down a little bit. So it's gonna come up again. Canon 2. Canon 2. Judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2.15. Responding to judicial and lawyer misconduct. A judge knowing that another judge has committed a violation of this code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge in other respects shall inform the Illinois Judicial Inquiry Board. A judge knowing a lawyer has committed a violation of Illinois rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the Illinois Registration and Disciplinary Commission. A judge noted another judge has committed a violation of the code that does not raise substantial question regarding honesty, trustworthiness, fitness, shall take appropriate action. A judge knowing a lawyer has committed a violation of the rules of professional conduct that does not raise a substantial question regarding honesty, trustworthiness, fitness, or a lawyer shall take appropriate action. A judge shall accord to every person who has a legal interest in a proceeding that person's lawyer, proceeding or that person's lawyer the right to be heard according to law. A judge shall uphold and promote the independence, integrity, impartiality in the judiciary and shall avoid impropriety, the appearance of impropriety in all the judge's activities. Rule 1.1, compliance with the law. A judge shall comply with the law, including the code. Rule 1.2, promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and appearance of impropriety. They have to even avoid just the appearance of impropriety. Rule 1.3, avoiding misuse of the prestige of judicial office. A judge shall not misuse the prestige of judicial office to advance personal economic interests of the judges or others, or allow others to do so. Canon 2, a judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2.1, giving precedence to the duties of judicial office. The judicial office, as prescribed by law, shall take precedence over all the judge's personal and extrajudicial activities. Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Rule 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice or engage in harassment, including but not limited to bias, prejudice, harassment based upon race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation, and shall not permit court staff, court officials, or other subjects to the judge's direction in court to do so. Proceedings before the court shall be conducted without manifesting bias or prejudice or engaging in harassment based upon attributes including but not limited to race, sex, gender identity, religion or national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation by or against lawyers, parties, witnesses, or others. D, the restrictions of paragraph B and C do not preclude judges or lawyers from making legitimate reference to listed factors or similar factors when they are relevant to an issue in the proceeding. A judge shall not retaliate against those who report violations of Rule 2.3. A violation of the Supreme Court of Illinois' non-discrimination and anti-harassment policy is a violation of this rule. Rule 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, or financial or other interests or relationships to influence the judge's judicial conduct or judgment. A judge shall not convey or permit others to convey the impression that they or any other organization is in a position to influence the judge. Rule 2.5, competence, diligence, and cooperation. A judge shall perform judicial administrative duties competently and diligently. A judge shall cooperate with other judges and court officials in administration of court business. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in the proceedings or that person's lawyer the right to be heard to law. A judge may encourage parties, procedure, and their lawyers to settle matters disputes, but a judge shall not act in a manner that coerces any party. Rule 2.7, responsibilities to decide. A judge shall hear and decide the matter assigned to the judge except when disqualification is required by 2.11 or other law. Comments. Although there are times when disqualification is necessary to protect the rights of litigants and preserve public confidence in the independence, integrity, and impartiality, judiciary judges must be available to decide matters that come before the courts. Unwarranted disqualification may bring public disfavor to the court and the judge personally. The dignity of the court, the judge's respect for fulfillment of judicial duties, and proper concern for the burdens that may impose upon judges' colleagues require that a judge not use disqualification to avoid case that present difficult, controversial, or unpopular issues. Rule 2.3 Decorum, demeanor, communication with jurors. A judge shall require order and decorum proceedings that before the court. A judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others whom the judge deals with in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's discretion and control. A judge shall not commend or criticize jurors for their verdict other than a court order and opinion in the proceeding. Rule 2.9 Ex parte communications. A judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. Rule 2.11 Disqualification. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might be reasonably questioned, including but not limited to following circumstances. Rule 2.12 Supervisory duties. A judge shall require court staff, court officials, and others subject to the judge's discretion and control to act in a manner consistent with the judge's obligations under this code. A judge with supervisory authority performance of other judges shall take reasonable measures to ensure that those judges properly discharge their judicial responsibilities, including and prompt disposition of matters before them, Ruling 2.16 Cooperation with disciplinary authorities. A judge shall cooperate and be candid and honest with judicial and lawyer disciplinary agencies. A judge shall not retaliate directly or indirectly against a person known or suspected to have assisted or cooperated in investigation of a judge or a lawyer. 3.1 Extrajudicial activities in general. A judge may engage in extrajudicial activity except prohibited by law or this code. However, when engaging in extrajudicial activities, a judge shall not participate in activities that appear to be reasonable person to undermine the judge's independence, integrity, and impartiality. Engage in conduct that would appear to be reasonable person to be conceive or make court premise staff, stationary equipment, or other resources except for incidental use. Supreme Court rules, Article 8, Illinois Rules of Professional Conduct. Okay, this is okay, like I told you, I was explaining to a gentleman before, you can't violate the Code of Judicial Conduct without violating the rules of professional conduct. You can't violate the rules of professional conduct without violating the Code of Judicial Conduct. You can't violate one code of the judicial conduct without violating multiple codes of judicial conduct, like I just read to you, and you can't violate one rule of professional conduct without violating multiple rules of professional conduct. Article 7, Illinois Rules of Professional Conduct, Preamble, Lawyer's Responsibility. People always question me, actually get upset with me, why do I gotta know this if my lawyer knows this is their job? Because they know you don't know what their job is, and they're not gonna do it if you don't demand that they do it. And if you don't know what their job description is, they aren't gonna do it. A lawyer is a member of the legal profession, as a representative of clients and officer of the legal system, and public citizen having special responsibility for the quality of justice. As a representative of clients, a lawyer performs various Functions as an advisory lawyer provides client with informed understanding of the client's legal rights and obligations, explains the practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system. As a negotiator, lawyer seeks to a result advantageous to the client but consistent with the requirements, honest in dealing with others. As an evaluator, a lawyer acts as examining the lawyer's legal affairs or reporting about them to the clients or to others. In addition to these representative functions, a lawyer may serve as a third-party neutral, non-representative role, helping the parties to resolve a dispute or other matters. Some of these rules apply directly to lawyers who have served as third-party neutrals. See e.g. Rules 1.12 and 2.4. In addition, there are rules that apply to lawyers who are not active in the practice of law or practicing law, even though they are acting in non-professional capacity. For example, a lawyer who commits fraud in the conduct of business is subject to discipline or engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. See Rule 8.4. In all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer should maintain communication with the client concerning the representation. A lawyer should keep in confidence information relating to the representation of a client, except so far as disclosure required, permitted by the rules of professional conduct or other law. A lawyer's conduct should conform from requirements of the law, both in professional service to clients and the lawyer's business and personal affairs. Lawyers should use the lawyer's procedures only for legitimate purposes and not harass or intimidate others. A lawyer should demonstrate respect for the legal system, those who serve it, including judges or other lawyers and public officials. While it is a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also a lawyer's duty to uphold legal process. As a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the legal profession. As a member of a learned profession, a lawyer should cultivate knowledge beyond its use for clients, employ that knowledge and reform the law, and work to strengthen legal education. In addition, lawyers further the public's understanding of the confidence of the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. 6. It is also the responsibility of those licensed as officers of the court to use their training, experience, and skills to provide services in the public interest for which compensation may not be available. This is the responsibility of those managed law firms to create an environment that is hospitable to rendering a reasonable amount of uncompensated services by lawyers to practicing that firm. Service in the public interest may take forms. This includes, but are not limited to, pro bono representations of persons unable to pay for legal service and assistance in the organization, bar efforts at law reform. An individual lawyer's effort in these areas is evidence. A lawyer's good character and fitness practice law, and the efforts of the bar as a whole are essential. The bar's maintenance of the professionalism to help monitor the quality of these activities and encourage and increase the delivery of legal service to persons limited to legal service to persons of limited means. Illinois Supreme Court Rule 756F requires disclosure with each lawyer's annual registration with Attorney Registration Disciplinary Commission and the approximate amount of his or her pro bono legal service and the approximate amount of qualified monetary contributions. 6B, the absence from the Illinois rules of counterpart to the ABA Model Rule 6 regarding pro bono and public service should not be interpreted as limiting the responsibility of lawyers to render uncompensated service in the public interest. Rather, rationale that is responsibility, it is not appropriate for disciplinary rules because it is not possible to articulate an appropriate disciplinary standing regarding pro bono and public service. Many of a lawyer's professional responsibilities are prescribed in the rules of professional conduct as well as in statute and procedural law. However, a lawyer is also guided by personal conscience and provision of professional peers. The lawyer should strive to attain the highest level of skill to improve the law and the legal profession and exemplify the legal profession's ideal of public service. A lawyer's responsibility as a representative of clients, officers of the legal system, and a public citizen are usually harmonious. Thus, when opposing party is well represented, a lawyer can be a zealous advocate on behalf of the client at the same time assume that justice is being done. So a lawyer can be sure that the preserving client confidence ordinarily serves the public interest because people are more likely to seek legal advice and therefore heed their legal obligations when they know their communications will be private. In the nature of law practice, however, conflicting responsibilities are encountered. Virtually all difficult ethical problems arise from conflict between the lawyer's responsibility to the clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. The rules of professional conduct often prescribe terms resolving these conflicts. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues may be resolved through the exercise of sensitive personal and moral judgment guided by the basic principles underlying the rules. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interest within the bounds of the law while maintaining a professional, courteous, and civil attitude towards all persons involved in the legal system. The legal profession is largely self-governing, although other professions also been granted powers of self-government. The legal profession is unique in respect because of the close relationship between the profession and a process of the government and law enforcement. This connection is manifested in the fact that ultimate authority over the legal profession is vested largely in the courts. To the extent that lawyers meet the obligations of their professional calling, the occasion for government regulation is obviated. Self-regulation also helps maintain a legal profession independent from government domination. An independent legal profession is an important force in preserving government under law. For abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for a right to practice. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest, and not in furtherance of parochial or self-interest concerns of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and public interest, which it serves. Lawyers play a vital role in the preservation of society. Fulfillment of this role requires an understanding by lawyers of their relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship scope. The rules of professional conduct are rules of reason. They should be interpreted with reference to purpose of legal representation in the law itself. Some of the rules are imperative, some cast shall not. These define proper contact or purpose of professional discipline. Others generally cast the term may, are permissive, defined across under the rules in which a lawyer has discretion to exercise professional judgment. No disciplinary action can be taken when a lawyer chooses not to act or acts within the bounds of such discretion. Other rules define the nature of the relationship between lawyers, and other rules are thus partly obligatory, disciplinary, and partly constructive and descriptive in that they define a lawyer's professional role. Many comments use the term should comments. The preamble scope do not add obligation to the rules, but provide guidance for participating in compliance with the rules. The rules presuppose a larger and legal context shaping a lawyer's role. The context includes the court rules and status regulating specific matters in licensure, laws defining public obligations of lawyers, substantive procedural law in general. Comments are sometimes used to alert lawyers to their responsibilities under such other law. Compliance with the rules, as with all law in an open society, depends primarily upon understanding the voluntary compliance. Secondary, they are reinforcement by peers and public opinion, and finally, when necessary, upon enforcement these disciplinary proceedings. The rules do not, however, exhaust the moral or ethical considerations should inform a lawyer of with, not while. Human activity can completely defined by legal rules. Rules simply provide a framework for ethical practice and law. Furthermore, for the purpose of determining a lawyer's authority, responsibility, principles, and subjective law, external and rules determine whether a client-lawyer relationship exists. Most of the duties flowing from the client-lawyer relationship attach only after the client has requested the lawyer to render legal service and the lawyer has agreed to do so. But there are some duties, such as that of confidentiality under Rule 1.6 attached when a lawyer agrees to consider whether client-lawyer relationship be established. Rule 1.8, whether a client-lawyer relationship exists or specific purpose depend on the circumstances of question. In fact, under various legal provisions, including constitutional, statutory, and common law, the responsibility of government lawyers may include authority concerning legal matters that ordinarily responses in the client and private clients relationships. For example, a lawyer for a government agency may have authority on behalf of the government to decide upon settlement or whether to appeal from an adverse judgment. Such authority in various respects and generally vested Attorney General and the State's Attorney General and State's Attorney and state government and federal counterparts. May be true in other government law officers. Also, lawyers under supervision of these officers may be authorized to represent several government agencies in intergovernment legal controversies and circumstances where a private lawyer could not represent multiple private clients. These rules do not advocate such authority. Failure to comply with an obligation prohibited imposed by a rule is a basis for invoking the disciplinary process. The rule's purpose is disciplinary assessment of a lawyer's conduct will be made on the basis of the fact and circumstances they existed at the time of the conduct in question. The recognition of the fact that the lawyer often has to act upon uncertain or incomplete evidence of a situation. More of the rules presuppose that whether or not discipline should be imposed for a violation and the severity of sanctions depend on the circumstances such as willingness and seriousness of the violation, exonerating factors, and whether there have been previous violations. Violation of rules should not itself give rise to cause of action against the lawyer, nor should it create a presumption in such a case that legal duty has been breached. In addition, violation of rule does not necessarily warrant any other non-disciplinary remedy, such as disqualifications of a lawyer in pending litigations. The rules are designed to provide guidance to lawyers and provide structure for regulating conduct through disciplinary agencies. They are not designed to be a basis for civil liability. Furthermore, the purpose of the rules can be subverted when they are involved by the opposing parties as procedural weapons. The fact that a rule is a just basis for a lawyer's self-assessment or sanctioning a lawyer under the administration of disciplinary authority does not imply an antagonist collateral proceedings transaction has standing to seek enforcement of the rule. Nevertheless, since the rules do establish standards for conduct by lawyers, a lawyer's violation of the rule may be evidence of breach and applicable standards of conduct. Comment accompanying each rule explains and illustrates the meaning and purpose of the rule. The preamble and this note on the scope provides general orientation, are instructive and not directive. The comments are intended to guide to interpretation, but the text of each rule and authoritative. The rules of professional conduct. So these are the rules that are commonly broken. Like I said, it's hard to violate just one rule, okay? Diligence. You'll have to print out the rules of professional conduct, and they all have their definitions, but you know what diligent means. They have to do things quick, fast, and in a hurry. Did they communicate that to you? You know, that's a lack of confidential of information. Every time I talk to somebody especially in criminal cases, about asking for a probable cause hearing, discovery. They always run and tell the judge and the state's attorney. No, they're not supposed to do that. Confidential information. Client with a diminished capacity. You can claim that because before any court can go proceed, you know, you must give informed consent. In order to give that informed consent, you need reasonable information to make an informed decision to give that informed consent. And the only way you can obtain that reasonable information is to have the legal education of those that you're opposing, which is your attorney, because you're going to cite your attorney for ineffective assistance of counsel for their failure to abide by and enforce the rules and the codes. All right. So you can claim a client with a diminished capacity because you don't have the legal knowledge, the reasonable knowledge to make an informed decision to give informed consent. Pretty easy, don't you think? That's client with a diminished capacity. Safekeeping property. I keep telling people in guardianship, probate, conservatorship, Rule 1.1, safekeeping property. Nobody does that. So people, if they violate one rule, they're violating not fail to safekeep property. That's a lack of competence. That's a lack of diligence. Okay, expediting litigation. That's rare and uncommon. That's rare. That's rare. Candid towards a tribunal. That's not too often. Fairness to the opposing party and counsel. A lot of times lawyers say, well, I didn't get this from the state's attorney, or I didn't get this from the other part, Failure to expedite litigation is not fairness to the opposing party. Diligence, lack of diligence, is not fairness to the opposing party. Everybody in that courtroom is supposed to see to it that all this happens, all right? Everybody in that courtroom, all the lawyers and judges in that courtroom, in any court, these are legal responsibilities of all lawyers and judges. Just having any knowledge that anybody is violating the rules of professional conduct or the code of judicial conduct, it's mandatory to report, and they don't even have to be involved in the case to do so. Responsibilities of the prosecutor, that rarely happens. So if you're involved in a criminal case, go to Rule 3.8. It tells you prosecutor can't proceed without probable cause, but they often will. They often will. And most of the time they won't even do it because they'll let the public defender con you into signing a piece of paper where you leave there with a felony, which is ineffective assistance of counsel in its entirety. I already went over the preamble, the rules of professional conduct with you, so that it's like that didn't exist. Truthful statements to others, that doesn't happen. Dealing with unrepresented persons, lawyers often do that. I had the state's attorney confront me on multiple occasions about cases, and I didn't have counsel. No counsel present. They shouldn't be talking with me. Excuse me, do you have counsel here with you? No? Okay, well, can you let me know so that way I can come back and talk to you and them? Responsibilities. See, I'll look at Rule 8.3, reporting professional misconduct. Rule 8.4, misconduct. So you'll find that it's rare that anybody abides by, enforces the rules and the codes, and that's where you get them. And that's why I put this. See, there's a little part up here. This little part right here explains it at the very beginning. It's a conspiracy against rights under the color of law. Jail Ford failed to report my counsel and the opposing party for multiple counts of misconduct on themselves for judicial misconduct. Remember, it's mandatory to report misconduct in the rules and the codes, no matter who it is. Even if it's themselves, they are legally required to report themselves. Okay, so then you go to the opposing party. The opposing party failed to report the judge for judicial misconduct and my counsel for ineffective assistance of counsel and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for effective assistance of counsel. Reporting misconduct is mandatory in both the Rule of Professional Conduct and the Code of Judicial Conduct. Failure to report misconduct, just as well as failure to enforce one's constitutional duties as prescribed in the rules of codes, the lack of the requirements of the Sixth Amendment of the U.S. Constitution is beyond ethical. The lack of effective assistance counsel doesn't allow for a fair trial, which shows due process didn't exist. This is a deprivation of rights in its entirety. It clearly shows the judges and the attorneys, in my case, committed a conspiracy against rights under color of law, which is prohibited. The willful deprivation of rights and privileges, no immunities can exist. No immunities can exist because that was under the color of law. That under the color of law means they did something that was illegal. You just think it's legal because of the lawyers and judges that did it to you. All right, prohibits conspiracies to injure because they work together. Everybody, all the lawyers and the judges are guilty of deprivation of rights because they didn't make sure this happened. You have a right to effective assistance of counsel. You know, they didn't make sure that happened, so you were denied a fair trial. You were denied due process. You were denied a quick and speedy trial. The limitations on the quick and speedy trial are often, almost always, exhausted. Look up a quick and speedy trial, and that's the easy way out. You know, failure to give you a quick and speedy trial, failure to comply with the limitations in the Quick and Speedy Trial Act, that means your case gets dismissed with prejudice. Okay, so that's the easy part. And then you want to throw all this at them, all this stuff they didn't do, you know, which isn't really that much. But you're going to have to go over it and explain it to them because they're going to act stupid, like they don't know what the hell you're talking about, you know, until you start going over it. Okay, looks like a lot. But it's not actually that much. Okay, so that's where is he? Okay. Alright, I talk a lot, so I'm always... Duty to disobey unlawful orders. Military duty to disobey unlawful orders. It's... Okay. Where is he? He's down here somewhere. I'm sorry, folks.
Tell the truth, don't be...
My attorney for ineffective assistance of counsel. Reporting misconduct is mandatory in both the Code of Judicial Conduct as well as the Rules of Professional Conduct. The state's attorney should as well then, Your Honor. You took an oath of public service and violation of that oath is treason. Not to cite my attorney and the state's attorney for violating the rules of professional conduct is a violation of that oath. In judicial conduct, you are also legally obligated and required by the Code of Conduct to do so. My attorney and the state's attorney are therefore required to cite you for judicial misconduct upon failure to do so. Informed consent is required before these proceedings can go forward. It is required I have reasonable knowledge to give informed consent, and that reasonable knowledge would be informing me exactly what due process is, and that's explained in the Rules of Professional Conduct and the Code of Judicial Conduct. A fair trial would require everyone in a court of law make sure that I have reasonable knowledge to give informed consent. Now, effective assistance of counsel is a double-edged sword and cuts every way you swing. Every attorney is required to abide by and enforce the rules of conduct as well as judges. Every lawyer and judge are required to abide by and enforce the Code of Judicial as well. Preferential treatment is forbidden in every court of law, and thus far you have given my attorney and the state's attorney preferential treatment, and they you. Let's not forget the requirements of a quick and speedy trial, which has limits. No one has explained any of this to me. With this being recently discovered, I ask that this case be dismissed with prejudice and for all of you to do what's required of law and report each other to the proper authorities. Thank you, Your Honor.
Okay, so there's a lot of stuff. They threw the case out. His brother told me they made him go back to court, made him take a jury trial or something, and threw it out during the trial. They lied to the public.
Okay, is lying to the public
Yes.
unethical?
Look up ethics in politics, wrongful evictions. It happens. So there's a lot of stuff I talk about. Living under corporate rule. Okay, that needs to stop, okay? Somebody was asking me about that. The Constitution guarantees due process to the right of all persons, not just citizens. This means non-citizens, including undocumented immigrants, are entitled to a fair treatment under the law. This includes the right to defend themselves in court. And how are they going to defend themselves in court if they don't have the legal knowledge, the reasonable knowledge to make an informed decision, to give informed consent, which is required, in due process, fair trial. But yes, the Constitution does say that anybody faced with any charges in a court of law in the United States has a right to due process, citizen or not. Okay, that's deprivation of rights. Okay, taking away their right to due process, their right to a fair trial, their right to effective assistance of counsel. You can't take that from anybody in a court of law. I told somebody about putting that statement they made on a writ of habeas corpus.
Okay, what happens if you don't get a quick and speedy trial? If you are not given a quick and speedy trial, you can file a motion to have the charges dismissed, potentially leading to your release. Violating the right to a speedy trial can result in the indictment being dismissed and any conviction being reversed. Any conviction being reversed. You could literally be doing time in prison, and simply because you were denied a quick and speedy trial, your conviction can be reversed. All right, even if the defendant is.
Penalties for putting loyalty to a politician over the oath. That's against the law. It's called treason.
Guilty. This can also give the defendant leverage in plea negotiations, lead to a harsher sentence in a.
Okay, and you know what makes this? What makes this so easy is that the letter of the law. The letter of the law is a mandate in interpreting the law. You do this word for word to the letter, as it is written, so that we all see, say, and hear the same thing. So it always made things self-explanatory for me. I knew that before I found the rules and the codes. When I was a kid in grammar school, when I was studying for the Constitution test, granted I had a couple years to go before I had to take the Constitution test, but I like reading, so I read about the Constitution. That took me to the Declaration of Independence. I found a lot of information in between, and that took me to the rule of law, and which I pretty well understood, especially when I found out about the letter of the law. And of course, that dragged me back to the Barons' War, the Magna Carta, the history of the rule of law. But That's what's always made law self-explanatory to me. The letter of the law. And, it's not often that anybody will abide by that. Remember, violating the letter of law are stiff penalties, fines, removal from public service, incarceration, okay? Actually, duty to disobey unlawful orders doesn't go for the military, but it goes for all public servants. And you could look that up. Penalties for a lawyer's failure to obtain client's informed consent. Any of you can hit your lawyer with that. How could they give you informed consent? You give them informed consent and you not knowing anything that I'm talking to you about. All I do is quote a bunch of laws in the public interest. To form a more perfect union. I love going over the Constitution. When the prosecutor knows of clear and convincing evidence establishing the defendant and the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek to remedy the conviction. And that's right there in Rule 3.8, special responsibilities of prosecutor, and that's true in every state. That's true in every court, whether it's state or federal, Okay, so, but you'll have to read the rule of professional conduct to understand it. So it's their remedy to overturn that wrongful conviction. People were asking me many a times, hey, I can find a lawyer to help me, exonerate, my case, overturn this wrongful conviction. They tell me about this exculpatory evidence they have, and they can't seem to find the right civil rights lawyers. Well, just get a bunch of people together with you, go over the rules of professional conduct with them, as well as the code of judicial conduct, point out Rule 3.8, tell them, hey, listen, it's the state's attorney's job to overturn my case because I got this exculpatory evidence proving I didn't do what they said I did. And so, but the state's attorney won't advertise that. One did in Chicago. I forgot her name. She's not state's attorney anymore. And she had a special crew to help overturn wrongful convictions, but it's their job. It's their job. It's in their job description to overturn wrongful convictions, okay? It's their job, but they're just not going to do it. Explain the conspiracy against rights under the color of law. Penalties for violating the letter of the law, disinformation, deprivation of rights, ethics violations in politics, the law in the workplace, discussing due process in probate court, penalties for threats of violence. People, you can go to jail for that, right? Threatening people with violence. Okay, but like I said, all this right here is basically what that guy said in court. He just gave a very condensed version of it, all right, of all this. So he just threw their secrets out there. Okay, see, but from there to right here, where it says, failure to do so would add to this conspiracy against rights under the color of law. So a young lady, she asked me, she said when she was filing, all you got to do is Google conspiracy against rights under the color of law complaint form and take this part right here. Just right here, because you can only use 500 words. So all the way down here, except for leave canon 2 and all that out, because it won't fit. It won't fit. So prohibits the conspiracy, injury, precedent, impose public interest trustees. This is how you maintain the public trust. Look up public trust doctrine, folks. Failure to do so would add to this conspiracy against rights under the color of law. And that's where you finish it. And look. Conspiracy against rights under the color of law complaint. Okay. Tells you where to file your complaint. See, you're going to want, see, everybody wants to tell me their story, and I keep telling them I don't need to hear your story. What you need to hear is what was supposed to happen at the very beginning with your lawyer, reviewing the rules of professional conduct and the code of judicial conduct, so that way you have a reasonable understanding of how things are supposed to play out in court. He should be letting you know about, expediting litigation, being diligent. Lawyers like to say the only time you can get a quick and speedy trial is in a criminal trial, but the rules of professional conduct say otherwise when it's required to be, diligent in expediting litigation, other things like that. But, it's up. I've been trying to get these people to do their jobs for years, and it ain't happening. So it's up to you people. I'm trying. I'm doing my best. And the only thing I can do is, try to recruit some of you. Remember, the Department of Justice doesn't work for politicians. Civil servants work for a government department. They do not work for politicians. I did a video on that. So no, they are there to serve the public interest. Everybody in public service takes an oath to the Constitution. The Constitution comes first. You cannot put your loyalties to a politician before you do the oath. That is violating the oath. Nobody can put anything above the oath. The oath always comes first in every public service. And saying I just took orders is not a defense. I was just doing my job is not a defense. If you knowingly and willingly violated the law, operating under the color of law. Look that up. Penalties for operating under the color of law. You are literally operating under the color of law if you are out there knowingly and willingly depriving some of their constitutional rights. And that's happening daily out there on a daily basis. And not just out on the streets, but in the courts. All you need to do is read the rules, the codes, look up the letter of the law, the rule of law. I mean, you quite literally, what Chief Justice of the U.S. Court said that the rule of law is eroding. Well, the penalties for violating the rule of law are stiff and stern: fines, removal of public service, and incarceration. And if that violation of the letter of law has caused death, the death penalty can be instated for that person that violated the rule of law. Okay, people, I'm just trying to get you used to understanding what's behind the oath they took. Violating the oath alone, penalties, fines, removal from public service. Violating the letter of law, penalties, fines, removal from public service. Violating the rule of law, penalties, fines, removal from public service. So many laws are being broken, and so many penalties, fines, and so much prison time is required for breaking all these goddamn laws. And nobody's being held accountable. Nobody's going to jail. Nobody's being fined. People are losing your life, liberty, and pursuit of happiness under the color of law. I need your help. I need your help to get our public servants to stop operating under the color of law. All right, people, I've been doing this for a long time, and I wasn't doing it just for me. I was doing it for you too, all of you. And I'm still doing it. My life is almost over. Everything's almost said and done. I got through what I had to get through, and barely got through on the skin of my teeth, but it's because of what I knew. And even though what I knew, it didn't work. You know why it didn't work? Because it was only me against our public servants. The cops, the lawyers, the judges, the courts, state, federal, our politicians. I took them all to task. Always reminded them of the oath, the penalties of their oath, and the requirements of that oath. And every situation is different, so I usually bring different laws with me when I go to them. That's what I'm trying to show you. That's what I'm trying to get you to understand. So when you go over anything I talk to you about, anything any lawyer or judge talks to you about, always refer to the letter of the law to get a complete and total understanding. Just drown out the sound of their voice. Have them hand it to you. Because they will use words you're unfamiliar with. They think they're dazzling you with brilliance, they're baffling you with bullshit. That's called disinformation. That's illegal. Penalties, fines, removal of public service, and incarceration. All right, people, peace and love for you. All right. Sorry I didn't get back to you sooner, but I've added migraines that lasted for a few days here since the last video. Lost a little weight, but I'm dealing with it. All right. For the most part, what matters most is you. What I do is for you. All of you. This is what gets me through the day. Being handicapped, alone, drive most people crazy, having no one to talk to. I really don't have the ability anymore to get in and out myself of the apartment without hurting myself. I need help. And that'll drive you crazy. It angers me. But what keeps me at bay, what keeps me at peace with myself, is knowing that somebody out there is listening and they're using the information I give them. to find their way. Okay, so this is Big Red was asking me some questions, and the big thing was understanding a lot of these laws. Basic legal obligations, act in the public interest, the letter of the law.
You can kick rocks if you don't like.
This is one of my memes. I say mean things when someone tries explaining to me the law, not realizing I know the penalties for violating the letter of the law as well as disinformation. Apologize, I can't do it. It's too difficult. They're dumber than a box of rocks. It's my fault. I should apologize. When will I be happy? When the apologies are over. I hate myself. I never realized there were so many rocks.
Like how I talk, I'm gonna keep on talking.
Okay, was talking to another gentleman. They said they certainly will hold you to the standard of attorney. That, my friend, is denying you a fair trial. The rules of professional conduct say you're a client of diminished capacity because you don't have the legal knowledge to make an informed decision, to give informed consent, holding you to the standards of a legal, learned, educated professional, but yet not holding the legal professionals to their constitutional duties prescribed in the rules of professional conduct. That's violating the rules and the codes in their entirety. You not only proved ineffective assistance of counsel, and with that being said, reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. You literally and unequivocally reproved the ineffectiveness of the court. Any other interpretation will be disinformation, and disinformation is legal for all lawyers and judges, punishable with fines, removal of public service, and incarceration. Once you prove ineffective assistance of counsel, which is easy because your lawyer didn't abide by the rules of professional conduct, you can prove the ineffectiveness of the court because nobody reported your lawyer for ineffective assistance of counsel. Violating the law. Okay. There we are. A conspiracy against rights under the color of the law. Okay. I wish you nothing but peace and love, my friends. May your Creator always be with you and rain many blessings. I wish you a long life and good health.